Hey YouTube family and GN subs, adjustment of status versus consular processing. Very, very important issue, folks. Very important considerations. I've been practicing law for a lot of time, so you're going to get my depth of knowledge and experience here on what you need to do. It sounds like a very simple issue. Adjustment of status, get your green card in the US, consular processing, get your green card out of the US, but it's not that simple, folks. All right, what is the difference between consular processing and adjustment of status, right? So adjustment of status is pretty simple. It's where you're adjusting in the United States under different sections of law, 245A, I or K. I won't go into that right now. I have other videos that talk about that. But the important point is if you're picking up the green card in the US versus consular processing when you're picking it up outside of the US. So why do one or the other? What is your main consideration? Let me tell you what your main consideration is, because this just became apparent, folks, in my practice, right? Adjustment of status is taking only 30 to 60 days these days. I think it's because they're electronic processing cases now. I don't know why it is, because you would think things would be really slow with the shutdown of the government and the current administration, but no, it is record speed, folks. So because you're getting the green card so quickly, I would file adjustment of status in the United States, right? Usually what happens is you want to consider consular processing because of travel. Generally, adjustment of statuses take a year at minimum. So during that year period, it takes 6 months to get what's called the work permit and the travel permit. So some clients of mine, they can't be stuck for the 6 months. Once you file the adjustment of status, you can't generally travel on your non-immigrant visa unless it is an H visa or an L visa, again, which is another consideration that we'll talk about. But people can't be stuck. They need to travel for business. So generally what they would do if the adjustment is taken a year, they would opt to consular process, right? Because then they can continue to travel on their non-immigrant temporary visa, E2, E3 visa, O1 visa, etc. So they could continue to travel on that non-immigrant visa while they're waiting for their appointment to be issued at the U.S. consulate abroad. So those are the main considerations. If you are in a period where adjustment of status interviews are taking place really fast, then file your adjustment. If these interviews are taking a year or longer and you have considerations with regard to travel, then you opt to consular process. Another consideration that you might want to consider whether or not to adjust or to consular process is something called retrogression. So let's say you file your adjustment of status in the United States and the visa numbers retrogress. Then it's going to take a long time to get the green card. You have considerations, again, with regard to travel, staying in status, extending your adjustment of status, etc. And certainly if you are from a country, China, India, Mexico, Philippines, then you have to consider, the length of time that it takes for your final action date to become a current. So you have to consider that when you're filing adjustment of status versus consular processing. You want to maintain status in the United States. If it's going to be a lengthy period of time, then basically you have no option but to consular process. Otherwise, those issues can be very tricky. I have videos that talk about strategies and what you might want to do in those instances, and you might want to take a peek at those. Hey, YouTube family and GN subs, thanks so much for watching GrayLaw TV. Click below, like and subscribe. You can get me only at GrayLaw.com, and if you want a consultation, you can send an email to maria@graylaw.com. We'll see you next week.